So I want to begin. When I use the word road tonight, I mean the road right-of-way. You're all surveyors, so I probably shouldn't have to explain that entirely, but I mean more than just the roadbed and the curb and the gutter, whatever. I mean the road right-of-way is the public benefit that the public gets through the various means of creating a right-of-way that we will talk about, and what they can do in the right-of-way, both while it exists and then later on if it's extinguished or vacated. So it's the right-of-way, when I say road, that I'm talking about. As a very general statement, road rights-of-way are usually easements, and we're going to talk about that because sometimes they're fee. When I say fee, I mean fee simple or fee title, meaning that somebody actually owned it, not just a burden of an easement. But for the most part, when you have a public road right-of-way, you have an easement. And the easement is limited to public travel and utilities. Now and again, you have an argument. A few years ago, maybe more than a few years ago now, there was a question of whether you could put a bike trail in a road right-of-way because a bike arguably was not a vehicle. And the courts uniformly said, well, it's a mode of transportation. It's like a sidewalk. Yeah, you can do that. Now and again, a municipality or somebody will want to encroach a park out into a right-of-way. And maybe somebody raises the devil about that, maybe not. But that's questionable. And when I'm representing a city and they want to do something like that, I say, well, why don't you put the parking for the park out in the right-of-way, because that is allowed. Right now around the state, it's kind of, no one's complaining, but when cities block off a street and allow restaurants and bars to have patrons out on the road, I don't think that's allowed by the easement. It certainly is fine for the building, for the property where the restaurant is located up to the middle of the right-of-way. We'll talk about that, but I'm not sure beyond that. But nobody's complaining, and that's just for us people here tonight. And I wouldn't complain either, because a restaurant's got to make money somehow. So the question tonight is, what is the burden? What is the easement? And what happens when the easement's lifted? To start, I want to talk about how a road is established. And that's the key to the question of what happens when you vacate the road. Is it an easement in which the adjoining property owners acquire title under what was the right-of-way, or is it a fee title where it stays with the government body? For plats prior to 2007, probably an easement, most likely an easement, but may not be an easement. And I would encourage you to look at the dedication language on the plat to see what was actually dedicated by the owner. This is Meyers on the law, if the plat says, as they usually do, I hereby dedicate to the public all right-of-ways and streets and shown on the plat, I tend to think that is an easement because of the language. If the dedication would say, I hereby convey, then maybe you've got a title, got a fee title in there. Chapter 505.01 was amended in 2007 so that from that point on, a platted road a road platted with a plat, rather, I should say, is clearly an easement. Is another question if you're platting on top of an existing right-of-way, as you do sometimes, maybe along a county road, or there's an existing town road and you're platting on both sides of it or whatever, you're still getting an easement, but you may need to look at the documentation for the underlying road if you're really questioning who owns the road once the road's vacated, who owns the land under the road, rather. So if the road was established by condemnation, look at the court order. It should state very clearly in there, either they're taking fee or they're taking an easement. Certainly most of the condemnation awards after, I'd say, 1950 were easement. But you need to look. You need to look at the extent of the road. The condemnation order should always be in the title records, by the way. Town roads, probably an easement. And if you've ever worked in chapter 164.07, towns, could happen today because it's still there, but primarily from the establishment of the state, probably up to 1940, towns would open roadway. There'd be a petition by the property owners. I think you had to have 6 freeholders within 3 miles of the road, and they'd petition the town board to open a road, and the town would hold a hearing and pay damages and all that. If you're not familiar with road orders, they can be hard to find. Up to 1974 or thereabouts, they were to be filed with the county auditor, not with the county recorder, and then maintained in the town road book. So a lot of times you're looking for a road order, you can't find it anywhere. And, depending on the county auditor, sometimes they actually keep the road orders in a file. And if not, you may have to go to the town hall. I've, in my experience, had to dig through town records for 100 years sometimes to find a road order. And even then, unique things happen. And just south of the prison on Highway 10 here, there was a road called, I think it's 52nd, and it was on a section line, so we knew there had to be a road order, but we could never find it in the Haven town records for the township for the road. And a few years ago, I was over in Palmer Township, just to the east of here, looking for a road and material in their road books. And here was a road order. And historically, the two towns were one until about 1870, I think it was. And so the road order for the road in Haven Township was over in Palmer Township. Had a similar experience in Lake of the Woods County. If you're up there, this is way in the north. Lake of the Woods is the last county formed in Minnesota, formed out of Beltrami County. And sometimes if you're looking for road orders and documents in Lake of the Woods County, you got to go down to the vault in Beltrami County because they're down there and they didn't get brought up to the new county. So you got to be creative. Most towns have a road book. If you ask them, the clerk probably doesn't know what you're talking about, but if you ask them and you push them, they'll get it for you. MnDOT, after 1950 or so, pretty much everything they took was easements. I don't run into MnDOT vacations very often because they don't vacate. They usually turn back to the town. They have their own rules on what's supposed to happen if the MnDOT no longer needs a public road right-of-way. It usually goes to the county and then from there. Incidentally, sometimes the counties get these pieces, and there's some parts on 169, I want to say by Zimmerman, but I'm not exactly sure, where 169 was realigned and there was extra right-of-way. They just didn't need it, and it wasn't appropriate to give it back to the local property owner or whatever, so they gave it to Sherburne County. And Sherburne County didn't want it. They wanted to put it in the hands of private property owners adjacent to the right-of-way, but they couldn't figure out how to do it. And they contacted the Attorney General's office, and well, they had no objection to it, but they couldn't figure out how to do it either. So in the end, sort of swallowed hard and registered title to the property, which took it out of the abstract system, and the state didn't object. They didn't consent, but they didn't object. So we got it back into private land. I registered title in Sherburne County's name, and then they gave it to the free and clear of the burden that MnDOT puts on this land. When they give it to the county, it can only be used for public purposes. And MnDOT then, or excuse me, the county then conveyed it to the local property owner for use in their business. So user roads, which is under 160.05, it's a pathway that the public has used and the government has maintained. And I think it's for 5 years, possibly 6, but If the public uses a pathway as a road and the government goes out for 5 consecutive years and spends money on the road, maybe graveling, maybe grading, whatever, it can become a public road by use and maintenance. If you have that type of road, you probably you have an easement. Of course, the issue with a road by use is what's the width, but that's for another day. In some areas, I don't see them around here, but in southern Minnesota and more northern Minnesota, we have judicial roads. And that's a unique character. What happened was, prior to amending the Minnesota Constitution in 1920, there was this argument about internal improvements, and the state couldn't make internal improvements. Only the counties could build roads because the counties were local. And what do you do when you have 2 counties side by side and they want to put a road down the middle of the county line? Well, neither county board had absolute jurisdiction. Sometime one county board would say we want to do it and the adjacent county would say no. So the legislature came up with this great system called judicial roads, where the people on both counties could apply to the district court judge, and the district court judge could order the road to be opened. It would be like a condemnation. The judge would appoint viewers to go out and decide, do they need a road? And they'd come back and say yes, and here's the alignment for the road. They'd hire a surveyor, and then the judge would award damages to the property owners from whom land was taken. And then the best part is the judge would send the bill to the counties, which you can imagine that was something they really appreciated getting, but they'd have to pay it. So there are judicial roads around the state, and if you're looking for a road order and you can't find anything, keep in mind if you're on a county line, you could have a judicial road. We have another, and I think that would be an easement too if you were to lift that burden of that judicial road. It would be vacated per county or town, whatever, has a jurisdiction over the road right now. In some parts of the state, in fact, I happen to live on one, there's something called a military road. And what happened probably pre-statehood, again, this argument about internal improvements, that the federal government should not be building local roads because people in New York didn't want to pay for roads in Minnesota. So to get things done around here in what at the time was the prairie and the forest, they would declare a military road, and the military road would run from Fort Douglas, which is down by Hastings, up to what is today Camp Ripley. It had a different name back then, I can't remember, but it was a military road that was open between the 2 points, and so they could justify spending federal money on a road. Even today on it's County Road 8 in Sherburne County where I live, some parts of it have a road dedication or a road easement, and many parts do not. Mine happens not to. It was important a couple of years ago when they were paving the road here, which I was all in favor of, but I had trees that would have probably been in the right of way, and I wouldn't allow the county to cut my trees down. And they were agreeable. They didn't argue with me. So, because I said, where's the road order if you want to cut the trees down? And we didn't argue after that. So anyway, they are around here, military roads. And there's a road called Common Law Dedication, which is another road. I think this is an easement. This is sort of a quasi-public type road. If people use a road and if the owner of the road doesn't stop them and the general public uses it over time, it can become a common law dedicated public road. It doesn't mean the township or the county or the city has to pay money to maintain it. It just means that the public gets to drive on it. This came up for me anyway, years ago when I was a young lawyer, up by Little Birch Lake. There was a community up there of mostly family members who had used this pathway from a public road into their cabins. No easement. Easement by prescription really would have been hard. Easement by prescriptions when you use somebody else's property and you go to court and prove that you have an easement across their property. Easement by prescription would have been hard because I think there were 20 people on this road. Every person would have to prove their use of the road in order to get access into their property. It happened to be that the guy at the public road, where it came off the public road, decided to put a fence up and put a gate up and stop people from doing that. You know, why, it's always puzzling to me why you buy lake property and go up and pick a fight with your neighbors, but I guess people do that. So he blocked the road, they hired me, and we went through the district court and court of appeals, and the court of appeals agreed there was a common law dedicated roadway. We had evidence from the sheriff and the postman, and I think utility drivers, propane and so on, that were in there. So that was an easement, I'm pretty sure. So that's pretty much how roads are there. Sometimes you do get a fee title, and I can think of a couple of cases. Some days, if the surveyors call me back, I'd like to talk about auditors' plats and registered land surveys. In a registered land survey, you technically cannot dedicate a road because the owner isn't signing the registered land survey, but you can make the road a tract with the consent of the property owner. So you get a certificate of title for the actual roadway, and then the township or city gets the certificate of title. And so fee title then would be in their name. Auditors' plats, they're a vexing problem on a good day. If you see a road in an auditor's plat, you probably can't ignore it, but auditors' plats cannot dedicate roads. Auditors' plats are a taxing instrument to begin with. And so if you see a road in an auditor's plat, you know you got a problem. Our office just settled a case up in, well, it's not quite settled, so I won't tell you where, but it was, there was a trail along a lake naturally, and I think around 1930, an auditor's plat was laid out, and they showed a 66-foot wide right-of-way on no basis whatsoever. They just showed there was this trail, a 66-foot wide right-of-way. Well, probably in the 1990s, a surveyor came along and platted the land, or some of the land, in the auditor's plat, and of course he showed a full 66-foot wide right-of-way, even though the person who owned the plat didn't own in there, but he claimed, well, it was in the auditor's plat, so my 505 plat, I'm going to show the same thing. Well, that, of course, caused a big problem because when surveys got done out there, it turned out that the people had built into that 66-foot area, and there were some zoning issues about how come you built your home into the right-of-way. So we had to get into a big fight with the county, and the county eventually, or I think it was township in this case, agreed they didn't have a full 66 feet. They had whatever the actual road was in there. So I'm open for questions, by the way. I'm hoping you got something for me here. So I'll keep going otherwise, and I'll turn it over to Dennis. So that's how roads are established. And so the next question is, what do you do with the road if it's platted but not open? It's not vacated, and it's in the plat. The town is saying, yeah, it's our road, but they don't want to maintain it. And what do you do with it? Well, as a general rule, each interior in a plat, each lot owner owns to the center of the road. And if the town's not using it, the lot owner gets to use that part of the plat that is not being used by the town. I have an example now, again, in Northern County. We're just getting into it, I suppose, but there's a plat, and the people on the east side, of course, they're my clients. They're pure and honest and great and wonderful. And the people on the west side are not so good. Well, the people on the west side parked a whole bunch of RVs and four-wheelers and equipment and stuff all over this roadway that's dedicated, sort of blocking my clients' access into their property. And the clients went to the town, and the town sort of, well, you know, we really don't want to get involved. We don't think they should put their stuff there, but we really don't want to get involved. So, because this is a neighborhood fight. So we'll probably end up in district court arguing that, well, the town certainly has an easement if they wish to open it. But until that time, the neighbor can't cross the center of the right-of-way onto the property of my clients with the adjoining lot on the east side and put their stuff on that property. On an exterior road on a plat, again, this is a general rule, on an exterior road, the roadway, if it's vacated or the underlying land under the easement, usually belongs entirely to the exterior lot adjacent to it. So that if you have a 66-foot wide dedicated right-of-way in a plat and the lot next to it, the road's vacated rather, all 66 feet would go to that person. I got a question. Do you want to just unmute and ask your question? That's probably easiest.
There we go. Can you hear me?
Yes.
All right. So you mentioned that with dedicated road right-of-way that has not been developed into a road, township or city has not accepted it as a road. So we see these a lot. You know, maybe it's a snake trail, you know, around a lake or something, but it is dedicated. So when you say the landowners can use that, do you mean they can build on it, something permanent, or do you mean that they can use it for parking or other non-permanent usages?
They can use it any way that is not inconsistent with the easement. So building, I think, would be prohibited, but parking on it, temporary storage, you know, as long as you can move it off there, because remember the town has the easement right to come in there and use it. So you can use it any way that's not inconsistent. In that regard, though, sometimes you find out someone puts particularly on a small lake lot, they put a septic drain field in a right of way. Well, it's really under the ground, but you know, if you were actually going to put a road in there, it would not work. You'd wreck the septic system. So it can be a problem. And by the way, when I represent townships and I find that, and the town board says, well, you know, we want to protect the lake, so we don't mind. I usually do a license agreement to allow the property owner to put the drain field or septic in there, and the license says that you have the town's permission to do this. You may install your system, but if we ever want it removed or changed or whatever, you've got to change it within 3 months or something like that. But you can do anything in the easement. It's just like a driveway easement. You know, you could plant grass and things, but you can't do anything that would interfere with the benefited property owner's use of the easement. Be the same with a public road easement.
So as a follow-up to that, David, is there a length of time that dedicated road right-of-way, if not developed into an acceptable road standard for the township or city, does it ever revert?
I paid Scott to ask this question because that's where I was going with this thing. So there's something called the Marketable Title Act, and the town, the government could lose it. The Marketable Title Act says that the intent is to remove stale records from the title system, so you don't clog up title. And so it's actually a very interesting question, Scott, because the town has not opened it. If you drive out to it, walk through it, you probably see trees and you wouldn't know it's a road right away, but it's there. And so after 40 years, and by the way, there's a possession exception to the Marketable Title Act. So if there's a trail down there, it may not be a public road everybody's using, but if it's a trail, you probably got enough to prevent the Marketable Title Act from extinguishing it. But let's say you don't have a trail. You just got trees. And after 40 years, does that road right of way not being used expire? And the answer is maybe, but the other side you got to remember is every time you sign a deed, then you reference a plat, lot 1, block 1, Marlin Addition, you reference the plat. And so the question is, by referencing the plat, are you reaffirming everything in the plat? And as an owner of a lot in a plat, you get the benefits of it. So there's no clear answer. I think the Court of Appeals we'll talk about a case a bit here ago where the Supreme Court extinguished an old town road. And ever since then, I think they've been running the other direction, saying, I don't think it's a good idea to extinguish roads. But anyway, that's it. So it's possible that the town has lost the benefit of the road by the Marketable Title Act after 40 years, possible. But again, there's a whole line of cases that say every time you reference the plat in a deed, you're reaffirming the plat. So, good question. I was talking about exterior lines. There is an exception that our office lost a couple of years ago. We shouldn't have, but we did. The person who platted property had an exterior road, and he owned the land beyond the exterior road too. He just wanted to plat part of his property. And so township never opened the road, just like you say. It wasn't extinguished by the 40-year act, but our client bought the platted lot on the exterior of the lot, and they wanted to put stuff on this roadway that wasn't being used. And so did the neighbor who had the meets and bounds property adjacent to the roadway. So we ended up in court, and we argued that, hey, it was in the plat. It was, the rules are that the exterior road in the plat goes to the lot within the plat. And the Court of Appeals said, no, not in this case. There's no evidence that the owner of the meets and bounds parcel meant to give up that road just to the person in the plat, because he had land adjacent to the plat that road would benefit. And so therefore they split the lot down the middle for both sides. So, anyway, there's a statute that was adopted in 1939, 507.17, that gives us a little bit of help. It says whenever you convey a platted lot, it's assumed you convey the title to the middle of the road under the easement. And so if the road is vacated, it's assumed that the person who laid out the plat did not retain that strip of land, and it should go to the adjoining lot. In fact, in the Torrance system, if you have Torrance property and you vacate a road, I'm an examiner of titles in a bunch of counties. By directive, I can add that vacated strip to your property. I only do it if there's no controversy. Another interesting case to think about is in the city of Duluth. There was a platted road, just like Scott said, that wasn't open, and it sort of meandered between properties down to a garage. And the people along the meander road, I suppose, got in an argument with their neighbor and tried to cut that driveway off, saying, well, the city's not using this road, so you, neighbor, leading to your garage, you don't get to use it either. So they got into a big fight. Well, it turns out that Duluth Home Rule Charter allows the city to grant driveways over unused right-of-way. I'm sure it was meant so that if you have a 66-foot wide right-of-way and you have 28 feet, let's say, of a roadbed, that Duluth could authorize a driveway access permit onto your property. But the court read it pretty broadly and said, because the charter had that language, that a private driveway could be built over a public road until such time as the public, if ever, government, Duluth, I guess in this case, would open it. So that's if you don't have a vacated road. If you have a vacated road, the rules are pretty much the same as I've talked about. A couple of things to think about, though. Counties have a very narrow right to vacate a road. They can't vacate a road unless they bring another road onto the property. And this came up for me recently in, it's St. Louis County. Our client bought entire sections of land that were wet and for a wetland bank to sell to the mining companies, I suppose. And there were county roads through some of this stuff. And we asked the county if they could vacate it. And they said, well, we really can't vacate it, but we'll revoke the county road status and give it back to the township. So I went to the township in advance of the county vacating, or the county revoking the county road status. And I got the town to to vacate, adopt a resolution vacating the road, because the town could do that upon the county revoking it. So we got the roads vacated that way. I thought the county was right though, because otherwise it runs into the difficulty of what do you do with the, when there's no new road, even though our client owned all the land on both sides, the county was still backed into that corner. So if you have MnDOT, I talked a little bit about this earlier, there's provisions in statute 164.44, a few others right there, that if MnDOT would happen to vacate road, they have to give it to the local government. If they condemned road, the local government doesn't want it, then they have to try to find the prior owner to see if they want to buy it back. And there's some issues on that. The Marketable Title Act, I talked about with Scott a little bit. Here's how that came into play. Like I said, the Marketable Title Act says you have to have a document in the county recorder's records within 40 years in order to maintain a right to property. Sterling Township had road orders, and they did what statute required them to do. When they laid out the road in the 1800s, they filed it with the county auditor, and they kept a copy for themselves. Well, somebody bought some land with a road, and I think it must have been it was certainly not improved, and the case isn't very clear. You talked about sort of a muddy trail, but somebody bought the land and shut the pathway down, I guess it was. And the township and adjoining property owner objected. They got to the Court of Appeals. The Court of Appeals said, hey, it's really not much of a road. It's just two rut road. Sometimes you can't drive on it because it's too wet. And Sterling Heights, you didn't file your documents with the county recorder within 40 years. So therefore, we determined that the Marketable Title Act extinguished it. Well, those of you that have been around a while know that that led to all the townships in the state filing road inventories under 164.55. By the way, some of those are pretty good and some are not so good, but that's what it was all about. The towns went out, inventoried their roads, and filed a recording with the county recorder's office so they could claim that, yes, we have a filing within 40 years. Incidentally, some of those you could remind, if you're doing work for townships, you could remind them that those were filed in the 1980s and they're soon coming up on the 40 years. So they may want to update those. Otherwise, they could, again, lose it to the Marketable Title Act. Well, the next couple of cases that came along, Wabito Township, when the town did the road inventory, of course, they had a lot of roads by use. They just put 66 feet down for the right of way for every road. And so that got to the Court of Appeals. And the question was, can a town, through a road inventory, expand its road by use and maintenance to 66 feet? And no, you can't do that. The court in that case said that the inventory is limited to the roadway plus an area for snow plowing. The legislature came by and narrowed that down under 160.05 right now. It's actual use. So if the town or city or county, I suppose, claims a roadway by use, they have to prove the width. They have to prove exactly how much road they've used and when they've used it. More recently, I think the courts have backed away from that Marketable Title Act stuff, thinking it's not a good idea to vacate roads. And there's a case, there's actually an easement out of Minnetonka called SAMPAIR, S-A-M-P-A-I-R. And that said the Marketable Title Act, there's a possession exception to Marketable Title Act. So if you don't have something recorded at the county recorder's office, but you're using it or someone's using whatever your right is, that the possession exception will take you outside the Marketable Title Act. And SAMPAIR told us that if the use is consistent with what the underlying document is, then it will not be lost to the Marketable Title Act. So I think most town roads, even minimum maintenance roads where not much is going on, you'll probably be saved if someone's driving on it once in a while. So a couple of more things and I'll turn it over to Dennis. There is something called abandonment for public roads, and it seldom happens. It's very hard to happen, but basically, and I made my notes here, the government has to take an affirmative and unequivocal act to abandon. The case I remember out of Wyndham was There was a city street or something like that, and it wasn't used, just like Scott talked about, but someone built a building on it, and it was very clear, and the city knew they were building a building on it. And later on, the city came back and said, well, we want to use this road. And the courts in that case said, no, it's, you stood back, you allowed them to improve the property. And by doing so, you gave up your right of way to that, that area. So one final point, and then I'll get to Dennis. And this is a fine point for lawyers, I suppose. It could be an easement, if not fee, but it could also be fee simple determinable. Fee simple determinable means you get the property unless a future action happens, and then I get it back. And the case, it's a good case that explains it, was the Paul Bunyan Trail up in Hubbard County. And what happened was the railroad in the 1880s, my phone here, well, not my phone, but it'll quit. It's probably some telemarketer telling me I need, you know, my interest rate on my credit card's going down or something. I don't know, but you guys get them too. Anyway, what happened was in the 1880s, the railroad bought land from the adjoining property owners for a rail line that became the Paul Bunyan Trail. And the deed said, it was a deed to the railroad, and it was a title was conveyed to the railroad with language that said, so long as this is used for a railroad. So in other words, the deed would say, you know, southwest of the northwest along this line, so long as this line is used for a railroad. Well, somebody along the Paul Bunyan Trail didn't like bicycles or didn't like people or didn't like something, and he sued and said the argument was, did this so long as language create an easement, in which case, once the railroad stopped using it for railway purposes, the entire fee would revert back to the adjoining owner, or was it a fee simple determinable with the reverter back to the adjoining owner? And the Supreme Court took it and said that words like so long as or until or during indicate a possibility of reverter and not easement. And then they went on, because I think they all wanted the bike trail to be there, to say that because there had been a subsequent deed around 1900, and the deed had said, you know, conveying all this land subject to the railroad, that established a deed in title and continued forward, so that the Marketable Title Act extinguished the right of reverter that would have existed prior to the enactment of that statute. So sometimes, not often, in a road, you might find that type of language. And I pointed out to you, if you're not sure, but if you see words like so long as or until or during, you probably got a fee simple determinable and not an easement. So anybody have questions? Otherwise, I'll let Dennis go. Somebody raised their hand, it says here, but I need a question. Unmute and ask a question.
Hi, David, it's Brittany. I have a
Brittany.
question for you. What
Brittany's
is
our top associate, by the way. Yes. Okay.
I don't know if I can take that title. What do you think is the #1 issue that comes up for you with roadway or right of ways? Like what do you see this most often in? Sorry, my child is in the background also.
Yeah, usually it's the extent, does it exist or does it not exist? And how did it get to be, how was the right of way established? That's the bigger issue. Somebody wants to cut trees, maybe along the right of way. A town wants to do some plowing, something, and somebody's out there stopping them. Or maybe the client's in our office saying, I got this big tree on my property and the county or city or town wants to cut the tree down. What can I do about it? It's the establishment is the one I run into most often. But I would say #2 after that would be what we're talking about tonight. The road is extinguished or vacated, and what do you do with it? Dennis is going to talk about this more a little bit, I think, but sometimes cities or governments get the wrong understanding. They think if they vacate a right-of-way, they can give it to somebody. Oftentimes an adjoining owner or somebody wants the road and the city says, fine, we don't want it. And they vacate it and they say, we hereby vacate and convey to maybe the entire road bed to the guy to the west in a plat, for example. the city or government has no right to do that. They can extinguish or vacate their easement, but they cannot determine fee title. That's independent of their actions. If they choose to vacate, fine, they vacate, but they don't get to determine what happens to the road underneath of that. Now, if you're representing cities or helping them, and one thing the city or town or county can do is to say, well, we're only going to vacate it if the adjoining owners agree that this is where the property is going to go. Otherwise, we're not going to vacate it. And that is some leverage sometimes. But cities cannot direct or government, when I say cities, cannot direct who gets what part of a right of way once it's vacated.
Okay, and so then it would just go back to whoever owns that property to the middle of the right of way.
Correct, or
Okay.
Whatever the rule is, yes.
Okay, thank you.
Anybody else?
Hi, David. This is Pat Veriguth talking up in Douglas
Pat.
County.
Yes.
We do a lot of right-of-way platting for road construction, buying new right-of-way.
Yes.
And we have existing right-of-way that has been claimed 66 feet for years. Is there any way to clean that right-of-way up if we can't find an existing owner for that? Like they've been selling up to the right-of-way line for 50, 60, 70, 80 years?
Is it, and you're talking about a right-of-way plat you've laid out, or?
Yep, we're trying to clean up the existing right-of-way that we're claiming.
Short of a district court, no. I think, no. And that's a good point. First, I'll say a right-of-way plat is a piece of paper with lines on it. It's not a conveying document, and it doesn't give the government any more than they had before. To me, it's sort of like the comprehensive land use plan. This is what we want to do. And so it's good to have, because then property owners and the planning department and so on can know that, well, this is probably going to be a road and we shouldn't allow a building in there or other permanent structure that we got to take out through a condemnation or otherwise. But, if you've actually used the entire 66 feet for under Minnesota statute 160.05, you probably have a road by use and maintenance, and you get to the extent of the right of way. I will say though, usually with government, I don't use that, because if you try to get a road by use and maintenance, you're in the district court and it's up to the judge. If you condemn it, the damages have to be minimal because you're already using it. And you certainly argue to the condemnation commissioners, well, we've got this by 160.05, but we want to just get it done. The nice thing about condemnation is the government is in charge. You get to set the agenda, you get to get it done, and it goes quicker. Yes, people can appeal after that, but you deposit after you put your appraisal together, you deposit the money with the court, and you can get your road done. If you actually go into court and litigate under 160.05, you could be in there for a year or more. So.
Okay, thank you.
Good question. Yeah. Anybody else?
Yes. Hi, David. This is Sarah Williams. I'm one of the law clerks at Rinky for the summer.
Hi, Sarah. Someday I'll get to meet you. By the way, for everybody else, our office is closed, so I don't even know our very good people that we've hired. So.
Yeah, I have a quick question. We obviously didn't learn this part in property law, but you talked about the abandonment of public roads and the case out of Wyndham. So how long does the property have to be considered like abandoned for? Because I'm just thinking, like, can people then just decide, like, I'm not going to apply for what I need. I'm just going to wait for this property to become abandoned and then build on it. And is that like something that you've seen often or not really?
Not very often. The courts do not like abandonment. The major case on this is one called Lake Pepin, and there was a railroad line and there was a beach down there, and the people somehow bought the railroad line, didn't want riffraff like us using a dedicated road into the lake because it was their lake. They didn't want us kind of people there. So they argued that, well, over time, nobody's used this road. The town hasn't used the road. And we planted some grass, and I think they had a concession stand or something on it like that for their own private use for nobody else. And so they said, well, the road was abandoned because we made this improvement and the government didn't stop us. The Supreme Court said no. Abandonment is really, really hard to get. under the adverse possession statute, 559.01, I think it is, you cannot adversely possess against the government. And this is in essence what you'd be doing with this abandonment. But they will allow it in like that Wyndham case where somebody built and the government saw them built, and it just became very unfair to say, well, tear your building down now because we want to build a road here. You're not going to see it very often.
Okay, gotcha. Thank you.
Yep. It's the Dennis Pederson Show. I'll be quiet.
Well, I will unmute, and I do want to share the screen. I want to put up a PowerPoint that has most of what I need on it. I have some other documents that I may or may not have time to get to, depending on how long we want to run with this dog and pony show. But
Dennis, you should be able to see your screen. You should give it a try.
let me just hit share screen. And let's see if I can slideshow. So I hope everybody can see that okay. I'm going to go through these fairly quickly. This is the kind of the gist of what we thought, or what the beginning of this was. There's kind of options for land surveyors for vacations of dedicated right-of-way. So in putting this together, we're really concerned in this case of dedicated right-of-way, land that was platted, strips that were created for right-of-way purposes at the time of the platting. And so when the local land authority, in this case the township, the road authority, the township received the platted streets, and at the date of this plat, and I'll get to that. Anyway, this is on Mille Lacs Lake, and I'm going to go down through these fairly quickly because the first 4 or 5, and here we go. This is the dedication of the plat. Do hereby dedicate, donate and dedicate to the public for public use forever the streets, alleys, roads, and parks shown on the plat. 1926.
Dennis, at least I can't see it.
Yeah, I think I'm gonna have to share a different screen.
Okay, it says you are screen sharing, but I'm not sure.
Yep, if you wanna hit that again, it'll ask you which screen of yours you'd like to share.
Okay. Well, I thought I did that, but apparently I didn't.
Dennis, maybe you're at the end of your PowerPoint. Go back to the beginning. Slide it up to the beginning. Maybe that'll do it.
No, I'm there. Anyway, well, that's going to kind of.
Well, there. Now you're there.
Okay. So probably when I went to the slideshow portion of it, it confused things a little bit. I don't know. Bear with me here. Can you see this options for this first page?
Yep,
We can see it now, Dennis. Yes.
All
so
right.
if you want to click out of the help too, that will,
Yeah, we
Get
get
bigger.
rid of that help and we should be fine. Okay. All right, we'll work with this. This is the plat. This is the area of this plat that we are concerned with. I'm going to just page through the various pages. This is the dedication part of the plat from 1926, Hunters Point. And we do hereby donate and dedicate to the public for public use forever the streets, avenues, alleys, roads, and parks as shown on this plat. Okay. So this is the area of concern. The town, none of this street, 50-foot street going to the lake is called Outlook Avenue. On the other side is an alley that's 30 feet wide. The ownerships in blue of lots 14, 15, and 16 are under one ownership. One person owns those. One person owns lot 112. And it turns out that the same party owns lot 13. These roads were never built. Matter of fact, if we go a couple more slides, what was built is where the orange is. Elm Street was built, the township bought lot 113 for road purposes, and then the road stubs north and south. But the last piece of the road, that 30-foot road going past lots 14, 15, and 16 was never built. So it's just sod, grass. This is nice lakeshore properties on Mille Lacs Lake. Township doesn't want the roads, and they say, we're willing to vacate the roads. So the question is, what does the surveyor have in terms of options to help out the township? Because as David pointed out, when the road is vacated, the adjoining landowners, by the process of reversion, get that part of the vacated road up to the center line of the road. So what's showing in this case is an attempt to kind of put center lines in, but there's a real question. Where does Outlook Avenue end as it goes around the little curve as it gets to the lake, and where does the alley begin? And where does the alley end? And is this a proper depiction of the center lines? And thus, does lot 112 automatically just get the pink portion? How do you decide how to divide that little white area? And then there's a complication. You got 52 feet of lake right-of-way, or lake access, not right-of-way, lake access. Now you have the DNR involved. Can you even vacate a public right-of-way onto public water? So anyway, this is kind of the basic premise of what we thought we could do. Initially, we thought, no problem. If they do, we can vacate it, and then we could decide how each property gets it if the adjoining landowners agree, and we could create descriptions that would specify that portion of the vacated right-of-way. Now, as David has stated, and I'm going to quote from a paragraph out of the 2018 MAX, or Minnesota Association of Townships Road Manual, says, when a town vacates a platted road, the land typically reverts to the adjoining landowners within the plat. If there are platted lots on both sides of the road, the owners on either side take to the center line of the right-of-way. If the road is on the outside edge of the plat, but still entirely within it, the adjoining owners within the plat usually receive the entire right-of-way area. Despite these relatively simple rules, the question of who gets what after a vacation can become very controversial. The point boards must keep in mind is that they do not decide who gets what after a vacation. This means the town boards must resist any temptation to allocate the land upon vacation, even if asked to do so by the adjacent owners or the petitioners. Reversion of the right-of-way occurs by operation of law, and if there is a dispute, the parties need to take the issue to district court. Now, we're trying to help the township and the adjoining landowners stay out of district court. But maybe that's not possible. We're not exactly sure. What the township has said is, we're not going to do anything unless we can get everybody to agree. Okay, that's good. We totally agree with that. So if you were going to give up the road entirely, the road bed, you could go a third and a third and a third along the road, or the lake frontage, and kind of create some angle points in the lines going to the lake. The township may want to retain a right-of-way. may want to keep an access for public, and it turns out that they do. So this is a viable option. And they would probably keep a portion of the lake frontage to allow the adjoining landowners in the plat to still get to the lake. And if they wanted to maintain a 30-foot strip on there, there would still be another piece. Now, what happens between lots 112 and lot 13, again, owned by the same parties, but two separate buildings, two separate houses, is really up to them. They can divide the pie any way they want after the vacation. But what the township wants to do is get a predetermined decision about where these lines will be drawn after the decision is made and after the vacation occurs, so that everybody agrees beforehand, and after the township has a public hearing and vacates, the next step occurs by agreement. So now, you know, David and I played a little point counterpoint in boundary law for years, and I tried never to agree completely with David, because what fun would that be? But in this case, and I can remember back in the day when somebody's building was in the right of way, the township would vacate 10 feet of the right of way. Now, according to this, can they do that? Well, maybe they can, maybe they can't. The point is, a lot of times they can do it if it gets done and it gets filed and gets recorded. Nobody contests the thing and it becomes a record. Was it completely legal? I don't know. Maybe was it by township policy? Maybe not, but it happened. So it gets some history to it.
Hey, Dennis.
It's great.
Maybe you're going to get to this point, but I just had a similar situation to this recently where the city was vacating a road that touched a public body of water. And they technically can't do that without approval from the Minnesota DNR.
I would agree. And I would just, there's three things I would comment to when they come out of a boundary law seminar from years ago. One of them, and maybe David has a comment on this also, it says Minnesota statute section 161.16 was governing trunk highways, was amended in 1989 to require a copy of an order vacating a portion of a road to be served upon the Commissioner of Natural Resources if a road terminates or abuts upon any public water, and further provides that such a copy be only for notification, does not create a right of intervention by the Commissioner of Natural Resources. The other thing I would mention is also out of that same seminar, the DNR have closed the application for vacation of the lot with the basis that the landowner had not provided that the lot was useless within the meaning of Minnesota statute 505.14, which prohibits the district court from vacating any street or alley that provides access for the public to a public water unless it appears that the street or alley or part thereof sought to be vacated is useless for the purpose in which it was laid out. So you got these little strips, roads that were never built. People walk down there and they watch the sunset. They go check out the lake. Maybe they drag a canoe down there, maybe not. There's no place to park. These don't function as public accesses. They are really just access points for the people who live in the area. So anyway, this came up as an interesting question.
That is a bone of contention, though. The DNR does not have the right to stop it, but they have the right to get notice. And in order to vacate a road, as you say in the plat, if anybody in the plat stands up and says, you know, I use that, I walk down there, there is a public purpose for it. And the town or the city has to make a finding there's no public purpose to do that. It's very hard, I think, to make that finding on any lake because it's a lake access. And for those that don't know this, by the way, if a road comes down to a lake, it is a public access. Some years ago, Dennis and I had a long cartway on Lake Mille Lacs on the other side. And
Oh, sure, bring that up.
that was in the Court of Appeals tomorrow for the third time, but not for what Dennis and I did. But anyway, we tried very hard to make sure that cartway did not touch Lake Mille Lacs at any location. Otherwise, it would have become a public access. So,
Because the other, I do have a statute 507.17 provides every conveyance of real estate which abuts upon a vacated street, alley, or other public right-of-way shall be construed to include either that part of the right-of-way or street which either by operation or presumption law attaches thereto upon such vacation. So.
And then there's a title standard, Dennis, that says caveat. This doesn't mean that it's determining who owns what. It just, 507.17 says you get something, but it doesn't say what you get. So
right, and that's kind of what's happening. The whole point of what we're saying here is the law says the adjoining landowners get to the center line. You tell me where the hell's the center line? I can't make a center line in that white area. I don't know how you do it. There is none. I don't even know which street is which. So anyway, there are some places where the surveyor can help and hopefully, you know, come up with some sort of solution that assists the township or whoever you're working with or the private landowners. When you buy a property and it says lot 112 and that part of vacated Outlook Street attaching there too, survey this for me, Mr. Surveyor. Good luck with that one. What is it? No, I don't know. So anyway, this was an attempt to kind of bring up some practical situations that come up concerning rights of way. David and I put together some materials, and David's done a great job of giving you a real history and a setup for roads and all that. I want to thank everybody who's been part of this. And we got a good turnout on this tonight. So this would have been the start of our summer MSPS summer meeting. We would have been on Green Lake tonight, sitting around a bonfire somewhere. And excuse me, now my phone is ringing. So hopefully my wife will pick it up, and she did. So we can have materials available if people would like some of the things we have in the background on this. If there are any questions you have about rights of way or easements, one of the things that I would mention before I close just my portion of it is that David mentioned that prior to 2007, there was a question over whether 505 right-of-ways created were to be easements or whether they had fee, because the statute stated that the statute or the dedication donation operated as if it were fee. So the bundle of rights, by filing the plat, creating the plat, appeared to convey fee. Yet what happens if you convey fee? If you convey fee and you vacate, the vacation doesn't, the road doesn't revert. You have to deed the road out. But if it's a vacation that or dedication that operates as if it were fee, you just get all the rights of fee, but the reversion stays in place. Then when you vacate, the land goes back to the underlying owner. So anything you would add to that, David?
Someone had a question, but no, I think the court cases keep saying that it's clear the grantor of the plat didn't intend to keep a strip of land. So despite what that statute used to say, and that before it's clarified, I think in most cases it's going to be determined to be an easement.
Right, and that's what we're saying, but the dedicator doesn't hold it. It's being held by the adjoining landowners.
Yeah, the dedicator is usually gone, dead,
Yep.
dissolved, whatever. Somebody had a question though, I want to get to that.
Yeah, was that Pat? Thought I saw Pat raise his hand, but
Yeah, that was me. I had one question about auditor's plats for David.
sure.
Yeah,
You said that you can't dedicate right away on an auditor's plat, right?
correct.
And then you can't vacate right away on an auditor's plat either, right?
I would say correct. And the reason is, first of all, an auditor's plat is a tax document. It really was never meant to be a conveying document, but it became simple to reference, lot 1, auditor's plat 25, whatever. But vacating, no, not at all. You'd need to go through some other vacation mechanism. I don't think you could do it. Not to say an auditor in the past hasn't laid an auditor's tract out over a road. They shouldn't have, but they did. But you can't vacate it with an auditor's plat.
So then if people can, will they lose access to the road then if they can't vacate the right away from the auditor's plat?
Well, the auditor's plat can show a road, which they'll do, but they can't dedicate it. So if the auditor can only give the public in the auditor's plat whatever has been established previously, maybe through a road order or through use or whatever. The auditor can show the road right away, but they can't dedicate it. There's one just north of downtown St. Cloud, I think Stearns County Auditor's Plat 11, and there's this line through it, and you think, well, that's the road. Well, no, if you read it, the auditor's plat very carefully, it said road drawn at random, which meant they didn't really know where it was in there. So, yeah, but you can't dedicate any because the owner's not signing. It was never meant to be a dedication grant type document, an auditor's plat. And you can't vacate it either. That's a different animal entirely.
So if you've got a prescriptive easement through there that isn't adjacent to a parcel there, and there, is that kind of a no man's land then?
I'm not clear. So you have an auditor's plat and you have a parcel of land, what, outside the plat or in the plat?
It's inside the plat, but then there's a road that doesn't exactly follow where the auditor's plat showed it.
Again, I guess I can tell you is two things. First, an auditor's plat, like I said, is taxing instrument. And I don't think you can resurvey from an auditor's plat. I think you have to go to the underlying legal description that the auditor used when preparing the plat. And that may or may not be consistent with the plat. In fact, I don't know if I've got a copy of it here. I'm on a survey title standards committee, and we actually have if you go online to Minnesota title standards, they're free now, you can get into them. But if you go to guideline number 12 at the end, it talks about auditor's plats in length and some statutory information along with some attorney general's opinions. But the auditor's plat is subject to the underlying legal description. So again, it's a taxing instrument. It's sort of like an early beacon to me. I mean, how the county auditors around the state have taken aerials and laid over the tax parcels on them. Very helpful to all of us. But you certainly can't determine boundaries absolutely from that. You have to go back to the underlying instrument.
David, wouldn't you agree that before they created the auditor's plat, they were simply meets and bounds descriptions of the properties? And
that's what I'm saying, Dennis. You got to go back to those descriptions.
But when they drew the street on, the land that resulted in the street still stayed in fee title, subject to the street easement. Whether the easement is where the auditor's plat shows it, or whether, as Pat says, there's some sort of prescriptive road that's in the area but doesn't really line up with the way the plat shows it.
The easement is independent of the auditor's plat. The auditor's plat can show what the auditor thinks he's seeing, but he can't create it and he can't expand it and he can't narrow it. Whatever's there is there, but it's independent of the auditor's plat. Does that make
Right.
sense?
Exactly.
I guess we're kind of running into that right now. We have 3 parcels on Lake Geneva that have houses that fall in that old auditor's plat, no man's land, and we're trying to vacate it, but if we can't vacate it, I'm not sure what to do there. So.
Well, it should be whatever public authority has the underlying road, a township, city, whatever, should have authority to vacate something. Yeah, I mean, the problem with all of this is auditors' plats get mixed in and used as a 505 plat. And I don't believe they were ever intended for that purpose, but that's how they got used. That was our case up in northern Minnesota I was telling you about, where we got into an argument with the township and we settled it. But yeah, the auditor's plat showed 66 feet and they didn't. They had a trail through there, but it was a trail people had kept up over the years. So they had something. We agreed they had right away. And I think my client said, well, you get curb to curb, it was 28 feet, but not 66. So they settled that. But yeah. So does that help you any with your question?
Maybe a little bit.
Yeah, you need to go back to see how that road was established. You know, for the moment, ignore the auditor's plat and say, well, how did this get to be a road? Probably by use. Probably somebody just started a trail. And
Yep.
eventually the auditor, you know, wanted to clear the descriptions of the complex meets and bounds, so they came up with an auditor's plat. So
Maybe you could upgrade it, Pat, to go with a boundary commission and just indicate, oh, that's right, you have a history with boundary commission. Never mind.
Thank you.
Moving right
Thank you.
along. This just be a little one though.
Yeah. All right. Thank you, gentlemen.
Well, thank you. Any other
nice
questions?
job.
Thank you. Any other questions? Anybody?
David, I got a question for you.
Okay.
In your research, did you come across or have any notes pertaining to statute 160.14, or is that for another topic?
Give me I don't have the statutes memorized, Russ. Which, I suppose I could quick turn my other computer on. What's it about? It's in the general road statute.
No, that's the
You're breaking up. I don't know if it's your computer or.
yeah, where the road authority goes out places, marks. Oh, okay. Where the road authority marks the boundaries, and then the landowner has a year to agree or.
Yeah, the constitutionality of that statute is in question. I guess I wouldn't rely on it. Yeah, it was. The idea was, yeah, the government would mark a boundary, and if you didn't complain after a year, the government got it. Based on the subsequent decisions, and for example, 160.05, that the government can't take more than they've used, I would really question that, Russ. Before I sent the bulldozer out there to start building my road, I'd make sure you got a good establishment on that one.
Thanks.
Did I burst your bubble on something?
No, but sometimes, we don't have such clear, let's just call it title, of what the road right of way is. So sometimes you think you got an interest, sometimes you don't. You hate to not exercise your rights as the government. So it puts you in a funny spot. That's where I was wondering what your comments were on that statute, because I think it's a way where if you have some sort of title to it or interest in it, you can retain yours or throw it out there to see.
Yeah, and like I say, Russ, usually when I run into those cases, I recommend that the government condemn, because damages are minimal. You've already got something in there. And, maybe you've got 30 feet and you got to take the extra 15 or something, whatever you're doing, to 36 feet to get 66 to do it. By the way, and I forgot to mention that 160.05 roads by use and maintenance do not apply to Torrens property. Torrens we didn't talk about tonight, but registered title is title you cannot adversely possess against. And so if you happen to come across a road by use or maintenance across Torrens property, you can't get it. Although you always want to look to see, did the road exist before title was registered? In which case it could have been established prior to the registration. And Torrens title under 508.25 is subject to public right-of-way. So those could be rare exceptions depending where you are in the state and how much Torrens property the county has. So anybody else have anything? Dennis, this is a nice 20-minute presentation you said we were going to do tonight. So
That's right. Yeah.
okay.
Well, you took it all up. Good grief.
I thought I wouldn't have enough. So anyway, I appreciate the opportunity to talk to you always. It's a pleasure. And sometime we should talk about registered land surveys and auditor's plats, because there's a lot of interesting nuances to those.
Okay. Well, I want to thank Denny and David for a great presentation, as well as a big thank you to our attendees for joining us this evening. As I mentioned earlier, today's webinar has been recorded and will be posted on the MSPS website for on-demand playback. You will also be receiving an email from us with a certificate of attendance and proof of 1 PDH. We welcome further attendee comments, suggestions, or input, so feel free to contact us. And at this time, if there's no other questions, I will turn the meeting over to Jürgen to begin the Chapter 5 meeting.
I'm going to get off. Thank you, everybody.
Thanks, David.
Yep.